teaching.
All right, welcome to Sacktown Talks. Today we have a very special guest, Nick Sanders with the Sutton Law Firm. We're going to talk a little political law initiatives, exciting stuff here. Well, Nick, welcome to the program. Thanks for joining us.
Thanks, Jared. Thanks for having me. Good to see you again.
Yeah, good to see you again. You know, I really was hoping you were going to have this really big, long, grizzly beard. You know, a lot of people are going beards, but you're keeping yours pretty neat. It's looking good.
I trimmed it just for you.
Yeah. How do you wear a mask with that beard?
Not safely, I believe.
Really?
I think that it falls outside of the regulations that the CDC's put forward, but I don't know.
Yeah, you know, I tried for a while and I just kept touching my face and I was like, I guess that's not what you're supposed to do. So I just I bailed on it, but.
On the beard entirely?
Yeah.
Can you grow a beard?
I don't know. I see, that's one of the questions I wanted to answer. And, you know, I don't think I'll ever know, but yeah, I'm fine with that, you know.
Next quarantine, perhaps.
Yeah, exactly. Well, Nick, thanks for joining us. You know, long time no see. A lot's going on or not going on because of the shutdown, and kind of what are the things you're working on? How's your work changed since the shutdown?
It's a little bit slower. You know, you would anticipate that people kind of get back on their heels a little bit while the shelter in place plays out. But we've been getting some interesting questions because, you know, politics doesn't stop.
Right.
People are trying to figure out how to deal with shelter in place, with staying at home, and continuing to do the work that they need to do. Sometimes that, you know, takes the form of figuring out how to properly do Zoom fundraisers. Other times it's the panic calls about initiatives, how they're going to get them on the ballot.
Right.
But they've become interesting questions. I'll say that. It's definitely not the normal run-of-the-mill type questions that we deal with on a day-to-day basis.
A new paradigm. You know, can you briefly kind of, for those not familiar with political law, can you just give us a little background on kind of what political law is and kind of how you got into it?
Sure. Political election law, kind of synonyms for the same thing. We deal in the laws that allow people to get on the ballot, and dealing with counting votes and how you deal with voting and voter access, ballot access, things like that. The political law aspect, I think, is more compliance with the rules around both lobbying and engaging in politics. So as you are well aware, as most people I think who listen to the podcast are well aware, there's a Byzantine system of laws in place if you want to actually engage in political speech. That's our specialty. That's the specialty of any of the political law firms around Sacramento.
You know, kind of an interesting time here. Legislature just reconvened yesterday for the first time in a while. And, you know, there's this big kind of argument between the Senate and the Assembly kind of about this remote voting issue, you know, whether that's constitutional or not. It looks kind of like the Senate and the Assembly attorneys have a different, you know, view on this. You know, are you familiar with this issue, and kind of, you know, what do you think the issue there is with remote voting in the legislature?
Yeah, so it all comes from, it's kind of the attendance requirement is what it's called. Both houses of the legislature the public has to be allowed to participate in hearings, to attend hearings. And when either chamber looked at the law, the Senate determined that attendance is not physical attendance. They don't have to be physically in the building, in the hearing room, standing up at the podium, speaking directly to legislators. And the Assembly has taken the opposite position. If you talk to people in either house, you know, lawyers in the Assembly and the Senate, I think they generally agree that the issue itself is theirs to decide. I think that the Assembly has acted with a little more caution. You know, the real threat is a lawsuit from the public, and you know, I've heard that Charles T. Munger is one of the people who has threatened to sue if the legislature doesn't convene in person. So the Assembly decided to take the position that they wanted to avoid that lawsuit altogether.
Right.
Now, when you get, this is a little legalistic, but there is a doctrine in jurisprudence called the political question doctrine. And, Jarrett, you're a lawyer, you've heard this one before, but essentially the courts in certain situations throw up their hands and say, it's not our job to deal with this. This is a political question. And, I have heard from several lawyers in the building, and I tend to agree that a court would probably throw up its hand and say the legislature gets to decide what it means to attend a hearing.
Right, through their assembly rules.
Absolutely.
Joint rules.
Yeah.
Interesting.
Right. There'd be some deference there, but it's a lawsuit is never something you can predict 100% of the time, right? Trial judges will do what trial judges want to do. And if you are the legislature, you don't want your legislation tied up with lawsuits. There's a question of anything that's passed without adhering to the attendance requirement, is that going to be overturned by a court? And even that still remains, right? The assembly is having session, but they've decided to let a certain number of people into hearings. If you let, 5 people into the hearing, have you met the attendance requirement? I don't know. Do you have to allow everyone into the hearing? And of course, all the assembly bills that are passed, even with people attending the hearings, so it has to go through the Senate itself. So if the Senate is doing things remotely and it is not meeting the attendance requirement, well, does that throw the assembly bills also into question?
So
several questions.
It'll be interesting, I guess, next few months to see how this plays out.
Definitely.
Something else that's going on right now is November elections coming up. In California, we have direct democracy with the initiative process.
A great process.
Kind of hoping to run down kind of the initiative process with you and kind of, what initiatives have I guess, met the November ballot deadline and which ones are kind of pending.
Sure. Yeah. Technically, there's only one measure on the ballot. It's a referendum on cash bail. That was done a while back. Went through the process and is definitely on the ballot. There are 4. The way that this works is, as you go out as a proponent. You have an idea. You want to pass a law. You hand it to the Attorney General. The Attorney General does his analysis, decides what the title of your initiative will be, what the summary of the provisions are, sends it back to you, and you can take the language of your law that you've written. You can take the title and summary that the Attorney General has produced, and you can put it on a petition. And you can send that around and gather a lot of signatures. For a constitutional amendment, it's almost 1 million. I think it's 997,000 this year. For just a normal law, just on the books in some sort of code, it's something like 623,000 signatures that you need in order to qualify. So many people, many groups have gone out and gathered signatures or are gathering signatures at this time. 4 of them have submitted their signatures and they're what's called eligible to qualify for the ballot. And on June 25th, the Secretary of State, the AG, will give their stamp of approval and they will appear on the ballot. So those 4 right now that are going to appear on the ballot, but aren't technically there yet because of the deadlines, are the criminal sentencing, parole, and data collection, DNA collection bill that's going to kind of roll back some of the criminal justice measures that were passed in 2018. The original split roll initiative that, this is a while back, but the CTA and a number of other folks who are seeking to split the property tax rolls between personal property and business properties, they had put forward an initiative last year and pursued signatures, got the number of signatures, turned them in, and then they decided to do it all over again with certain new thresholds. So that original one that they submitted is eligible and will appear on the ballot, or at least at this time will appear on the ballot if it's not withdrawn by June 25th. And then The other, we'll get into it, but the other, they submitted signatures last month. So there may be 2 split roll measures on the ballot, but they may withdraw the original one.
Oh, interesting.
The third initiative that's eligible that will probably appear on ballot, Prop 10, all over again. This is allowing local jurisdictions to impose their own rent control measures, whether or not they're a charter city. It's Michael Weinstein tried this last election cycle. It did not pass, and he's trying it all over again. The fourth one is about property tax base transferring for those above 55 years of age. It basically makes it easier for older folks to move to a new house without incurring a larger property tax liability. A house that they bought in the 60s, they don't pay much in property tax. Well, if they were to move to a smaller house, if they were to downsize, they were probably going to be paying more in property taxes. And if they're on a fixed income, that makes a difficult decision to make.
Right.
But that initiative would allow them to transfer their current property taxes to a new home.
Okay. So basically you said 1 has officially, I guess, qualified as on the ballot, and there's 4 kind of pending certification right now?
They will qualify. It's what's called eligible. So the Secretary of State has to give a stamp of approval on them, and that occurs on June 25th. But those 4 that I just mentioned, they have submitted enough signatures to qualify for the November ballot. So they will be on the ballot unless they're pulled back.
I think I saw in the news today there was one dealing with privacy, or there's a couple initiatives people are still turning signatures in. So what's the path for those to get on the November ballot?
So there are 3 that signatures have been submitted already. So right now, what you do is when you submit your signatures in each county, you gather your petitions and you go deliver a bunch of boxes to the registrar of voters, and each county's registrars counts up their county signatures and sends them up to the Secretary of State. So 3 initiatives have had those signatures submitted to the county registrars of voters. The first one is the AB5 replacement. That's the Uber, Lyft, DoorDash, Instacart coalition, which is seeking to create a new classification for app-based workers who do driving, deliveries, that sort of thing.
Right.
So that is currently being counted. I have heard that they are optimistic with what they've submitted. They've submitted quite a few. The second initiative that's been submitted is the kind of resubmission of that split roll tax that I talked about earlier.
Okay.
It's thought that if this one qualifies, then the previous one will be withdrawn. I haven't heard lately whether or not that's still under consideration, but the resubmission, which is being counted right now, it raises the threshold from 2 million to 3 million. If you are under 3 million under this resubmitted one, then your property taxes are not changed to current value. Gives some other, narrows the exceptions for small businesses who own property and have fewer than 50 employees. So there are additional qualifications if you want to qualify for that exemption. And it sets kind of specific allocations to schools and community colleges. So it's different. Raises a threshold in one case, makes it more difficult to qualify for exemption in another, puts different allocations. It's the typical horse trading that you would see coming up with legislative language. It's just unique in this situation that they have already submitted, I believe it was 1.7 million signatures.
Wow.
And then did it all over again. So that one is also being counted. The third one, I'm not going to touch the politics of it. It's constantly being talked about, but it's one of the dialysis measures to institute new regulations into dialysis. That's also being currently counted. So those are the people who have gathered enough signatures and are going to qualify. There are also 5 that, we'll call them potential initiatives. Initiatives that got their title and summary, went out there, are gathering signatures, and at some point during the process, told the Secretary of State, we've gathered at least 25% of the signatures necessary to qualify our initiative. This is a new requirement that came in about 4 years ago. Essentially what happens is once you reach that 25% threshold, you trigger legislative hearings. which allows the legislature to speak with the proponents, really engage them in depth, and come up with some sort of negotiated settlement to avoid having an initiative go on the ballot. If they can do it through the normal legislative process in the building, then they don't need to go to the ballot box. It was one of the attempts to curb the number of initiatives on the ballot, because I think, what was it, 2 or 4 years ago, we had 20-something initiatives on the ballot at the statewide level. It was just getting to be a lot.
Right.
So
that 25% threshold, is that just self-certified, or is there some sort of vetting by the county to see you're actually at that number?
Essentially self-certified, yeah.
Okay.
You just say, we got it, and we're going forward. We need a hearing.
Is there any way to evaluate kind of where a campaign is, or kind of, measure if one has a certain number of signatures or not?
From the outside,
yeah.
Only checking in with the campaign itself. I think that campaigns are generally straightforward when it comes to the signatures that they're gathering. If they're trying to raise money, they don't want to be seen out there giving false information to the public.
Right.
So you can get a general sense of where they're at if they are being forthcoming about.
With the shelter-in-place orders, you kind of heard signature gathering came to a halt.
Yeah.
Are you still hearing or seeing that signature gatherings are occurring right now throughout the state?
There are some ways that people are gathering signatures. We have dealt in the past with kind of unique methods to get out there and get signatures. Now it's required. As a firm, we've kind of talked about this, kicked it back and forth. It's always been kind of a fun mind experiment. What would happen if you couldn't go out there and gather signatures?
Right.
Back in the 70s, 80s, what's that?
Who thought that would actually happen?
No, exactly. Yeah. Back in the 70s and 80s, there were several campaigns that actually experimented with mailing petitions to voters. Especially now, campaigns have very advanced voter rolls where they know who their supporters are. So, if you print a petition that's got 1 or 2 signatures on it, you put it in the mail, you send it to the people who support it, you give them a self-addressed stamped envelope, and they send it back. I heard from a consultant recently who was active in environmental movements in the 70s, and he said that they did that pretty regularly. It is very expensive to do this, right? Printing petitions in general, especially at the statewide level, there's a lot of petitions you're going to have to print if you're only allowing 1 or 2 signature blocks. And then you have to give them a self-addressed stamped envelope, and then you have to track them. If you are just blanket bombing all sorts of voters with that sort of information, it's just not cost effective.
Do you need to have a wet signature, or could you do an email campaign and have people scan signatures in? Or
that is near and dear to my heart. There was an initiative which was seeking to qualify for the November 2020 ballot that would allow electronic signatures on initiative petitions.
Wow. And
it failed yesterday.
That's too bad.
So,
the DocuSign.
Yes.
Wow. Yes. That'd be amazing.
I was really hoping for that. That was
100 initiatives every.
Yeah.
A Twitter campaign. Wow.
Steve Churchwell, one of the political law attorneys in Sacramento, he litigated this issue a decade ago, I want to say. Maybe a little less, a little more than that. He was seeking to try to figure out how to qualify using electronic signatures. There was this technology where I think that they had created it for this purpose, but it was, an iPad. The signature gatherer could go around, or you could give it to someone, and if they signed it with the iPad, there was a machine that would recreate the signature as they sign it onto a petition using a pen held by this robotic arm.
Oh, wow.
In some remote location. And the court did not believe that was an appropriate signature for submission.
Right.
So this initiative would have, what's that?
Yeah, I guess it kind of, you were saying earlier that, the signatures get turned into the county where they were collected. Kind of what happens in a situation where you're a voter signing a petition in a different county than you're registered to vote in? Is that not counted, or, can they verify you in another county?
So you would have to submit the petition in the county where the voter is registered. So the reason that the registrar of voters does it is that they verify that each registrar holds their county's voter rolls, and that registrar has to match the signature in their petition from their county with their voter rolls to make sure that it's the same person. So what would happen is this remote location would sort between which county you were in. So Sacramento County, Jerry, you're signing over there in Sacramento County, you would transmit it to a machine in, I don't know, LA County, but it would be in a stack of petitions destined for the Sacramento County registrar.
Okay, interesting. But like, let's say I took a trip to LA and I signed a petition while I was in LA, and they
not valid.
In, would that count or?
No, you would. Yeah, it would not count if it was submitted to the LA registrar of voters.
Okay, interesting. Wow.
Yeah.
Kind of like takes me to my next question about, how do they verify these signatures? Kind of what are the different methods of verifying that? And kind of, in your opinion, if you're running a campaign, what method would you go with?
Sure. There's well, first, what actually happens on the ground? Signature, there's a lot of talk about how expensive signature gathering is. Signature gathering firms, especially the good ones, are very adept at taking in petitions and verifying the signatures themselves. It used to be, 10, 20 years ago, you could guess at a validity rate of, 70%. You would hope for that. You would be going through trying to go through voter rolls, trying to check things off, making sure the duplicates aren't in the petitions, and hoping for that 70%. Now, especially if you're talking about a local initiative, they are very high, almost exact in a lot of cases.
Wow.
In smaller jurisdictions. So what'll happen is these signature gathering firms get the voter rolls. They don't have the signatures. They don't have individual signatures, but they know who are registered voters, and they know where their address is. And so they will look at the petitions and see this person is a registered voter or this person isn't a registered voter. And if they're not a registered voter, they cross them out. They also go through and make sure that there are no duplicates in the petitions, cross those out. And then what they're left with is a pool of what they believe are valid signatures to submit to the county. When it gets to the county, the registrar does what's called a raw count, where they take out the petitions, literally count the number of signatures, and if it's at least the number necessary to qualify, then they pass it on to actual verification.
Now, is this a machine count, or is this, people physically, counting 1, 2?
People physically counting. Now, we always recommend when we're turning in petitions, we often submit petitions on behalf of our clients. When we submit petitions, and signature gathering firms will do this too, you group them, right? If you have a petition that has 20 signature blocks and they're all filled out, you rubber band all those together. You rubber band all the ones that have 19 signatures. You rubber band all the ones that have 18 signatures, et cetera. Okay. So when the registrar gets it, they kind of spot check, they make sure that it's there, and then they can count it real quickly. It's basic arithmetic rather than going through and actually counting each one with ordinal numbers.
So kind of, looking at the Secretary of State's website, they have some recommended dates for if you're, having an initiative and you're, turning signatures in. They had this like April 21st date for initiatives to get their signatures in. Is that a hard date, or, can you still qualify after that, after turning your signatures in after that April 21 date?
Sure. That April 21 date is definitely why it's on the top of everyone's mind right now. You've seen a lot of articles come out. You see people talking about it. It is not a hard date, but it is a good recommendation. What happens is what I was describing, that raw count, right? Then it goes to the back and they actually verify each signature. They have 30 days. Each registrar has 30 days, and this is business days, not calendar days, 30 business days to go through and verify their petitions. That doesn't count Memorial Day, which is coming up this month.
Right.
Doesn't count weekends. And it doesn't count other holidays that might come up. Or if there's a closure, especially for something like COVID, if there's a closure, well, it's not going to count.
Wow.
So the recommended date allows registrars that 30 business days, allows them to gather it, gives them a little bit of wiggle room, and allows them to submit to the Secretary of State, and it gives the Secretary of State time to process all the information and put it in. If everything were to work perfectly, which it never does, but if everything were to work perfectly, if the signature verification by the circulators was very good, if there were a ton of signatures, if the registrar was able to do it quickly, you could see an initiative qualify if it were submitted as late as next week. I believe that the 30 working days, allowing the Secretary of State 1 day to process all the information, would put it at the 13th.
Wow. Okay.
But again, that is everything working perfectly. That is everything being delivered on time. That is everyone being able to get it done, and essentially people waiting for their step in the process.
Right.
I would say at this point, if an initiative hasn't been submitted, there's a serious risk to not making it.
I know like a lot of county courts, for example, are closed, or a lot of these county election offices closed right now because of COVID.
No, they're all open. I have heard registrars talk about the difficulty of keeping them open, but they know that they have to be there counting signatures. So I'm trying to remember which county. There was a large county that we spoke with a registrar, and essentially what they are doing is having part of their staff come in, because signature verification is sitting in front of a computer. These people who work at the registrars, they sit in front of a computer, they type in the name of the voter, and their official voter registration signature pops up on the screen in front of them. And they look at the petition, and they look at their screen, and they see whether or not it matches, right? Wow. And registrars go out of their way to try to let these things qualify, right? So they look for indications. Well, if the J is the same in Jarrett, well, it doesn't matter that there's 3 peaks rather than 4 or something like that in the signature. They can look at this. This is their job. They can look at it and tell that it's there.
Are there any legal actions, I guess, to challenge these signature gathering efforts, saying, oh, that's not a real signature? Are there methods where people engage a firm like yourselves to try to disqualify these signatures?
Not at this point in the process. When we are challenging signatures, that usually occurs after the election, when we're doing vote by mail ballots or provisional ballots, looking at those, the same exact matching system, right? But at this point, petitions that have been turned in are not public record.
Okay.
We don't get to see them. The proponents wouldn't get to see them again unless they didn't qualify and and the proponents want to check. Mm-hmm. They're just kept secret for the most part.
Well, I guess what if one does qualify? Let's say one barely qualifies. Have you ever seen a legal challenge, basically demanding a recount or kind of extra scrutiny like you would see in an election?
Yes, but a court is very rarely going to allow that to go forward unless there can be proof of some sort of malfeasance. It's going to be very difficult for an action to move forward against something that's qualified. And that's not to say that it doesn't exist, right? There are cases where, especially at the local level, right, you only need 1,000 signatures to qualify. Well, some malfeasance is going to get you a lot longer way than it would at the state level. So if you have a circulator who's copying over signatures, for instance, then that's gonna push an initiative a lot further along than it would at the state level.
Yeah, I'm just kind of thinking like, a county like LA County, if, they have maybe, 1 million signatures they're looking at with all these different initiatives, mm-hmm. It could be a pretty tedious task to be going through those. So
it is. I think the more likely action at this point is not about qualification for this ballot. But one of the other legal issues is that once you receive that title and summary I talked about earlier, mm-hmm. From the Attorney General, you have 180 days until that title and summary expires. Essentially, it's gone. You got to resubmit. You got to go through the process again. Anything you've gathered is off to the wind. we haven't thought this through extensively, so I can't give you the full legal bases, but that 180-day requirement is now a little suspect. If the government is telling you that you can't go out and collect signatures, right? It's, if they were to change that requirement to 8 days rather than 180 days, well, the court would look at it and say, that's ridiculous. You can't gather 997,000 signatures in 8 days. Right. Well, if it's 180 days less 2 months of shutdown, well, then a court might look at it and say, that's ridiculous. You can't expect people to gather signatures in that amount of time. Now, no one's filed that action. We haven't heard anyone wanting to file that action necessarily, but that is probably the most likely litigation that I can think of right now.
So you're talking about, these pending measures that have reached the 25%, but are still, kind of been shut down because the signature gathering is kind of paused. Yeah. That, they might not be able to make 2022 because of the 180-day issue, but, they might get extensions. Is that kind of what you're saying? Right.
Yeah, that would be, if I were counseling them, that would be what I would recommend, is to try to get that extension. Right. Now, in a lot of cases, they already have the signatures, right? There are 5, we got a little sidetracked, but there are 5 initiatives that have this 25%, right? There's the new privacy law. Alistair McTaggart has proposed a new law to increase digital privacy. That one has the 25%, hasn't qualified yet. There is the Center for Regenerative Medicine, California Institute for Regenerative Medicine, the stem cell research facility. They have a bond measure that I have heard it has enough signatures to qualify for the ballot, but it wants a little extra kick, and it's trying to decide whether or not it wants to submit for November 2020. Right. Interestingly, that group has decided to post its petition online in order to get the extra signatures, to push it kind of over the edge.
Right.
So right now, if you were to go on the website, you can print out their petition, sign their petition, and mail it in. That was another kind of one besides mailing out petitions individually. You can also place it online, right? They've decided to engage in that. My understanding is that they feel comfortable that they have this number of signatures that they need, but they want to kind of kick it up. Like I said, with the split roll tax, they turned in 1.7 million, right? In a lot of cases, these initiatives will jack up their signature count to show a coalition of people behind them, not just the bare minimum to qualify an initiative.
Right.
So, the other question is whether these initiatives do want to go forward. So 2 others are the medical negligence cap raise and the plastics tax, right? These are 2 initiatives that kind of gathered a lot of attention when they were initially submitted. They've been out on the streets. I know at least the medical negligence cap raise has said that it has enough signatures to qualify for the ballot, but both of those initiatives seem to have said they don't want to. They've looked at the situation, they've looked at what's going to be on November 2020, and they've said, we're just going to take a step back. Now is not the time.
Right.
Now, in a lot of cases, it's not about gathering signatures, right? It's a decision, well, especially for, let's say, the medical negligence tax or the medical negligence cap raise. They have to go out there and they have to raise money from plaintiffs' lawyers, right? That's the group that's going to give them money. Well, right now, courts aren't open. Plaintiffs' lawyers aren't in court. Now's not a great time for them to raise some money. So they looked at the landscape. They said, this isn't our time to fight this fight. We'll wait. And if they want to submit at the 180 days, if they want to submit later and qualify for 2022, they seem to have enough signatures to do that. The plastics tax, I haven't heard whether or not they have enough signatures, but they have also seemed to have decided that they don't want to qualify for the November ballot.
They're going to wait. How much, you were talking about the mail-in and the costs, what is the cost of a campaign to get, to qualify with paid signature gatherers you've seen this cycle?
Quite a lot. I don't think we've seen a per signature count, obviously, in a while, right? It's been 2 months since we've dealt with this. It's felt like several years, but I think the last, we're talking $7 to $12 per signature.
Wow.
I think. And if you're, if you need 977,000 ballot signatures, but you want to turn in, again, I'm going to keep using split roll as the example just because that's the one that, was recently turned in. They submitted the 1.7 million twice. Well, you can do the math. Let's take the average. Let's take $10, 1.7, and then multiply it by 2 because they did 2 different signature gathering drives. It's a lot of money.
Right. And, so basically you're saying that they could have spent $20 million qualifying this twice. Who are the groups behind, putting that one on the ballot?
For split roll specifically?
Right.
That's California Teachers Association is the main backers. A lot of the public sector unions, I believe, are also heavily involved. But I know that CTA is the biggest backer.
No, interesting. Circling back on the, signature counting, there's 2 methods. There's the raw count and there's, a percentage count. Could you kind of describe how that percentage count works and kind of when that's utilized?
Yeah, so all the deadlines we're talking about now, this April 21st, the mid-March, mid-May, whatever you want to call it, these are all based on what's called a random sample. That is the default in all counties. Certain jurisdictions allow you to select, San Diego City, if you submit a city initiative, you're allowed to select whether you want a full count or a random sample. But at the state level, when you're submitting an initiative, you put in to the counties take it in the back, and they take a small percentage of the initiative, of the signatures, and they go through and calculate the number of valid signatures of that sample. And it's 1-to-1, right? So if you need 100,000 in a certain county and they take a sample of, 3,000 and 90% of that sample are valid signatures, then they just extrapolate that out. They say, you turned in 100, 90% validity on our sample size, so we're going to say you turned in 90,000, right? If an initiative on its random sample gets more than 110%, then it passes through. The registrars say, we've done our random sample, you've hit 110%, you're good to go, right? But there are what's called penalties. So we talked about the 1-to-1. Let's say you turned in your 90% whatever. They extrapolate that out. But the biggest issue is duplicate signatures. It is the odds of getting a duplicate signature in a very small percentage of the signatures out there is pretty remote. So when a registrar sees a duplicate signature in their random sample, they apply a penalty. Right now, I think that the calculation has it about a little over 1% of your validity is knocked out. So if they say you have a 90% validity, well, you just got knocked down to 88 point something percent because of the duplicate, right? It's a big number. Right. So we talked about what happens if you get the 110%, you move on, you qualified, you're good to go. If you get below 95%, you don't qualify. They say, based on a random sample, you don't qualify. In some cases, at a local level, some local jurisdictions will allow you to appeal that and say, we want a full count now. That's not the case at the state level. What happens is if you get between 95 and 110%, then they go into a full count. I think the Secretary of State calls it a full check, but they essentially all it is they go through every single signature and they check it, right? It goes from extrapolating out on a 1-to-1 basis, less penalties, to actually checking every single signature. And what that happens at that point is the registrars are allowed an extra 30 working days, again, not calendar days, but working days to get that done. So in the case where a full count is necessary, if you don't get that 110%, you will have blown well past the deadline.
So, the Secretary of State is the one who certifies these for the ballot. The counties are the ones who count the ballots. Is there any, vetting by the Secretary of State of the county's work, or does the Secretary of State always take the county's word for it?
unless there's reason for the Secretary of State to take issue with the counties, he's going to defer to his county registrars. Registrars take their job seriously. Each one has a different approach. When I think one of the Southern California, I don't want to name which counties, right? Tell them, but I know that certain Southern California counties, like especially in Southern California, they go through as many as 7 different checks. So if the initial check falls through, if the first line of review says this signature doesn't match, well, then it goes to another person, another worker who has to say whether or not they agree. Then it gets up to the supervisor, and the supervisor has access to other signature records, right? So it's not just what's on the voter registration document, but they can look at, land deeds or other registration documents that you've signed with the county, and compare maybe your signature's changed since you registered to vote at 18, right? And then if they look at all the signatures, don't agree, it gets passed on. And at the end of the day, the registrar, him or herself, actually does look at some signatures that have been rejected many times and has to make the decision based on all the signatures that this voter may have signed with the county, whether or not their signature matches. So there's a very intensive process.
Kind of touching back on the split roll, how they have 2, I guess, initiatives pending right now. Could they decide to do one in 2020 and hold one for 2022 at this point?
Now that they've submitted, I don't believe that they can. They could have held signatures on the second one and decided to do it after the deadline so that they qualified for 2022. But as of right now, unless they pull one back, which would require them to do then a 3rd round of signature gathering, it could be those 2 are going to qualify for November 2020, assuming that this one that they submitted has a sufficient number of signatures.
Yeah. Earlier, you were talking about this kind of new procedure that came in a few years ago with the 25% in the legislative hearings. Kind of what is the legislative deadline for, I guess, negotiating some of these off?
Those have passed.
Those have passed.
So those, yeah.
So at this point, the legislature, obviously is not having hearings anymore, but, I think, maybe there's like a June, I thought there was like a June deadline for them to kind of maybe put initiatives of their own on the ballot.
Yeah, and that's actually a big question that we've been debating inside of the firm right now is, will the legislature take this opportunity to pass their own bills? There's at least one bond measure that's making its way through that will probably qualify for the ballot. But with a very sparse field of initiatives on the ballot, it seems like it would be right for the legislature to put their own issues forward. Now, that's obviously difficult, right? Not every assembly member is going to be in person in session, right? There are a number who don't want to be there because of health reasons. Mark Sollier had his own issues with COVID, right? So some people can't attend, aren't attending. So anytime there's anything controversial, it's probably going to be pretty difficult for them to get it through a full vote. But that would be something to watch, I think, is what the legislature decides to do.
And the legislature, I guess, to put an initiative for November, are they, is it June, or can they, put something on in August or before the end of the deadline? When is that?
So they have early August is the deadline for the ballots to be set, but the legislature has its own deadline. I don't know it off the top of my head. I think you're right. It's in June that the legislature just has to pass through. And, it does have to go through the full process in order to make it to the ballot. Right. So we will be seeing them fairly soon, I would imagine.
Now, at what point is the ballot locked in, or can some of these initiatives, I guess, take their initiatives off if they so?
You can't really take them off at this point if they've been submitted. I think they're set, I want to say August 7th or 17th, just off the top of my head. It's 88 days before the election is when the ballots are set. That's usually a much bigger deal in local initiatives because the way that it works at the local level is much less regimented. There are fewer parties involved. You just have to get it before the city council or county board of supervisors before that E-88 days before the election so that they can vote to put it on the ballot or have it go on itself.
The split roll campaign has been, talked about on this podcast a couple times the last few weeks. A lot of interest on that. Have you seen a no campaign form on that specific initiative yet?
I have not, although I anticipate that it has been discussed and the players are probably already ready to go.
Kind of, the other side, I guess, political laws, the money, the speech, kind of when would you normally see a no campaign kind of gearing up to, I guess, line up to oppose these initiatives?
That's another interesting question. Typically, it would be after the June election, right? But now that we've had our primary election, it is a new day. I would probably say everyone is in the mode of running campaigns beginning in late June, starting their campaigns for the November election, but there's nothing saying that they can't get started right now. It's probably, there are pros and cons to starting now, right? If you're going to be doing digital ads, now's probably a pretty good time to be targeting people with digital ads because they're stuck with their computer. Yeah, exactly. But you're not going to have the same effect that you would in jurisdiction by jurisdiction, right? If you're trying to turn, our firm is based in San Francisco, right? We do a lot of work on San Francisco initiatives, on San Francisco candidates, that sort of thing. Campaigns in San Francisco are run door to door. It's still very local politics. You still have to deal with canvassers, and that's just not possible right now. People in San Francisco don't really care about their Facebook ads, although they're on Facebook as much as anyone else. Right. It's the way that you turn San Francisco is through Democratic clubs, which have to meet and give their endorsements. It's going door to door and handing out literature. There are mailers. Everyone does mailers, and mailers are good, and they are just as effective in San Francisco as elsewhere, but it's just a different style of campaign. LA is completely different from San Francisco. San Diego, even more different, right? It's going to be an interesting strategic decision on where and when campaigns start right now, especially, I think, split roll, which is going to have to turn certain jurisdictions rather than others.
One interesting issue that's coming up is this November election. Will we be able to go out and physically vote? A lot of people are talking about, it should just be a straight up mail election. Kind of a lot of people are opposed to, an all mail election. Kind of what are the legal issues you're seeing with this November ballot coming up and, people not being able to vote in person?
I would guess we're going to have an all mail election. We have now several local counties that are using the new voting system. Sacramento used it last election cycle. LA is supposed to use it for the first time this cycle. Essentially, everyone gets a mail-in ballot, and you're going to have voting centers, and you can go vote at these voting centers. They may have something similar rolled out statewide on an emergency basis, but with all of this lead time, with all of California's experience with vote by mail, which has been increasing quite a bit over the past few cycles, I think that you're going to see an all vote by mail election in November.
What's some of the controversy around, vote by mail? As you said, California has been voting by mail for a long time, but there seems to be kind of, I guess, maybe it's more of a national conversation, but kind of like a lot of opposition to kind of this all mail election.
It's tough. I mean, running an all mail election is difficult. It is difficult logistically for the registrars who need to take in all the mail-in ballots and registers or verify signatures in the same way we talked about before, right? It is an individual sitting in front of a computer, holding up their envelope from the mail-in ballot and comparing the signature on the envelope to the signature on their screen. It's time consuming, it's difficult, takes a long time, and as you know, California is famous for having elections take a long time to verify, and people are getting kind of sick of it. Well, this is going to take a lot longer if everything is vote by mail.
Right.
The others are an increase in, we'll call ballot access for vote by mail ballots, right? Very recently, just this last election cycle in 2018, we allowed what's called ballot harvesting, which is in the past when you filled out your vote by mail ballot, you were allowed to turn it in, right? You could go to the polling place, drop it in the box. You could turn it in to the mailbox, have it sent out. Now you can bring it to, a local group that you're involved in, and that group can collect all the ballots and turn them in, right? If you are an active member of your union, you can go to your union meeting and turn in your ballot, right?
Right.
This raises a lot of not legal questions necessarily, right? But if you show up to a local political group that you're active in and you are filling out your ballot at this meeting, right? No one might tell you to fill out your ballot in one way or another. But the implied pressure of discussing endorsements and having your ballot seen by the people to your left and right might pressure you to vote in a way that you might not have before.
I guess you could start seeing employers saying, okay, I have 1,000 employees. Let's all fill our ballots out together and turn them in together. Kind of.
Yeah. So there are definitely rules on intimidating people into voting a certain way. You can't entice them. You can't give them money to vote certain ways. You can't give them anything of value to vote a certain way. You can't intimidate them to vote a certain way. It's just, but practically making sure that doesn't happen gets increasingly difficult, especially when these people don't have an outlet to say, oh, well, I vote in person, right?
No pressure. Wow.
No pressure.
Well, Nick, thank you so much for joining us. It's been very interesting talking about these new issues coming up. It's going to be an interesting year. You want to give the listeners, I guess, some of your information. So in case they have some questions, they can reach out to you or the wonderful folks at the Sutton firm. Sure.
So Sutton Law Firm, based out of San Francisco. We have offices in LA and Sacramento as well. Our website is campaignlawyers.com. You can go check us out. If you want to reach out to me specifically, my email address is nsanders, as in Nick Sanders, at campaignlawyers.com. And our main line, which can get to any of our offices, is 415-732-7700.
Great. Awesome. Well, thank you so much, Nick. Great talking with you.
Thanks, Jared.
All right.
Good to see you.
Later. Thanks.
All right. Bye.
Are called dreamers.